Welcome to Houston Baptist University's Psych 4326, The Psychology of Death and Dying. Reminder, these presentations are only intended to highlight some important or difficult points from the chapter. They are in no way comprehensive and do not include all the material students will be held responsible for on exams. You are expected to completely and thoroughly engage with all the required learning materials. Exams in this course may include questions taken from the textbook readings, videos, and PowerPoint presentations. This presentation covers some important topics from Chapter 16 in our textbook. Make sure you read all of the chapter and take notes. There's much more material in this chapter than we are covering in this presentation. For most issues related to death, dying, and bereavement, state law governs what to be done and how it's to be done. This results in different laws and procedures applying in different states. Therefore, this chapter only addresses legal issues and structures in a general way. When no specific legislation covers a particular subject, decisions must still be made in individual cases. One way of making such decisions is by drawing on precedents set by prior court decisions, which constitutes case law. When neither legislature nor the courts have addressed a topic, the legal system turns to common law, which draws from the standard legal dictionaries, such as Black's Law Dictionary. The Conversation Project is a private, nonprofit organization that's dedicated to helping people discuss their wishes for end-of-life care. They understand and confront the difficulty and uncomfortableness of such discussions and have created free, downloadable starter kits that offer some ways to initiate such discussions. Check out their video by clicking on this link. What's a living will? Is that like a will? Well, not exactly. A living will is valid when you're still living. The broad legal context for living wills is the right to privacy and the right of competent decision makers to give or withhold informed consent and to accept or refuse interventions, even when that might affect the timing of the individual's death. This is a good attempt to name a substitute or surrogate decision maker in the event that you are incapacitated. It requires healthcare workers to follow the directives of the individual. The difficulty is that living wills may not anticipate every relevant feature that might arise. Their significance and force may be subject to interpretation and dispute among family members and professional care providers. Because of the limitations and potential difficulties with living wills, some prefer a durable power of attorney for making decisions in healthcare matters. Power of attorney is a legal doctrine whereby one individual authorizes another individual or group to make decisions and take actions on behalf of the first individual in specific circumstances or for a specified period of time. A durable power of attorney continues in force until it is revoked, especially when the individual who authorized it is no longer able to act as a competent decision maker. Advantages include that it empowers someone else, a healthcare proxy, to make decisions on behalf of an individual in any and all circumstances that the document covers. The proxy can be instructed to refuse all interventions, to insist on all interventions, or to approve some and reject others. Durable powers of attorney in healthcare matters are now in force in all states and the District of Columbia. Other options include documents such as the POLST, Physician Orders for Life-Sustaining Treatment, or the DNR, Do Not Resuscitate. These allow continuously ill or frail patients to choose the treatments they want or do not want and ensure that their wishes are documented and will be honored. It's important to differentiate between real and only apparent death. There are several definitions of death. Is it lack of heartbeat, lack of brain waves, lack of breathing? We have machines that can make the heart beat and the lungs breathe. If someone is on one of those machines, are they alive or dead? Make sure you read through the UDDA definition of death in your textbook on page 454. Determination of death is subject to human limitations and fallibility. The Harvard Committee in 2001 developed the following criteria for irreversible coma as a basis for certifying that death has occurred. Should be unresponsive, no movements or breathing, no reflexes, and a flat electroencephalogram, no brain waves. These criteria apply only to patients who are in a coma. Most people die under the care of a physician or in an organized hospice or home care program. In such circumstances, a physician or other authorized person usually determines the time and cause of death. That information is recorded on a death certificate, which is then signed and certified by the physician or authorized person. The death certificate serves a broad range of public and private functions, such as claiming life insurance and other death benefits, disposition of property rights, and investigating crime. Deaths come under the jurisdiction of a coroner or medical examiner. If the person who died was not under the care of a physician, if the death occurred suddenly, if there's no reason to suspect foul play, and in all cases of accident, suicide, or homicide. The era of organ and tissue donations began in the 1950s when medical advances made it possible to transplant specific organs and tissues from one individual to another. Many transplantable human tissues can be sterilized, frozen, and kept in storage for some time. It's estimated that approximately 95% of all deaths in our society could lead to tissue donation. In actuality, only 5% lead to organ donation. You can also donate an entire body for medical education and research. There's a huge gap between the need for organs and tissue and actual donations. As many as 18 candidates on the National Transplant Waiting List die every day in the U.S. because no suitable organs become available for transplantation. Donors can be living donors or non-living deceased donors. Living donors may be directed donors who are helping a specific transplant candidate. Living donation has many advantages. The medical history is known, consent is obtained, the organ is removed under ideal conditions, and usually lasts longer, and so on. Non-living donors represent approximately 62% of all donors. Most of the time, a non-living organ donor has died suddenly and often traumatically of a cerebrovascular event or external blow to the head. Signing the organ donor card is not enough. If you want to donate, you should do two things. 1. Report your decision to a first-person consent registry, and 2. Convey your wishes clearly to your next of kin. Individuals who die without a valid will are said to have died in a state and without a testament stating their wishes. In order to avoid the expense and delay of the probate process, it's important to have a will in which you document your final wishes. In a will, you dispose of your property as you wish. Wills can be changed at any time up to the testator's death, assuming the individual remains of sound mind, and gives evidence of intent to make the change. To document intent to make the change, a supplementary document called a codicil is used. A codicil leaves the previous document intact while altering one or more of its provisions. The most recent valid will governs the disposition of the estate. Make sure you read Chapter 13 thoroughly and understand the terms at the back of the chapter. There's so much more than we are covering in this presentation. I'll see you in Chapter 17.